The next matter to come before the court this morning is State of Ohio versus William J. Horvath. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal if you're the appellant. I will be keeping time, but you can also keep track of it on the screen by our bailiff's desk. Please don't use the names during oral argument of any minors or victims of crime, as we are recording this presentation and we'll be posting it on our YouTube channel. Excuse me. We have read the briefs. We are ready to proceed with the live.
Thank you, Your Honors, and good morning. My name is Attorney Sid Freeman. I have the honor today of representing the appellant in this case, Mr. William Horvath. Opposing me today, counsel for the City of Barberton, Kelly Parker. Your Honors, may it please the court, I called yesterday. You may hear that I'm hoarse. I was pretty sick actually earlier this week. I have had it tested. I'm negative for COVID. So I'm feeling much better. I don't think I'm contagious, which is why I'm here today arguing. So.
Yes, thank you, counsel. We understand that you called and we appreciate the phone call.
Thank you. Your Honors, may it please the court. I have received, in fact I just received today, the hard copy of the order overruling my motion to show cause in the civil action. As you know from our briefs, there's actually two appeals pending right now. One is from a civil action that I brought on behalf of Mr. Horvath in the Common Pleas Court in Summit County for injunction to keep the City of Barberton from tearing down his house. That case, as I'm sure you're aware, is still pending, and I just received today an order overruling my motion to show cause in that action, in that appeal. Just briefly, in the civil appeal, court granted a temporary injunction to prevent the City of Barberton from doing anything to tear down the house, the subject property, during the pendency of the appeal, based upon its concerns for resolving issues that I raised in my briefs concerning the constitutionality of the statute, both as applied and as written. The court considered that significant enough to do the very unusual step of granting my motion for injunction under the authority that I love to cite, Reeves versus Legal Browns. Based upon that, at the trial court level, in this particular matter, in this criminal action, trial counsel, Matt Furtado, raised the issue of the injunction with the trial judge and asked for, what he requested actually was a stay. Now, Your Honors, I'm not going to re-argue the issue of show cause. This court found that my motion to show cause in the civil appeal was not appropriate because the criminal action did not seek to actually tear down the property. And since it didn't actually seek to tear down the property, the injunction didn't apply to it, and I'm not going to re-argue that. What I am going to say, though, however, is that the trial court, at the point when Mr. Furtado raised the motion to stay, the court at that point in time needed to ask itself a question. And that question was whether, if it proceeded, was it doing something that would deprive this court of the ability in the civil action to affirm, to reverse, or to issue an appropriate order. And let me just sort of explain. It may be clear in my briefs, maybe not, but the citation upon which this, this criminal action was maintained was the same citation that we were challenging for its constitutionality, both as applied and as written, in the civil case. It was a citation that was issued in August of 2020. And so the complaint in this case said that Mr. Horvath, by the way, Your Honors, I forgot to ask if I could have 5 minutes. I'd like to reserve 5 minutes.
Certainly.
Okay, I apologize. So anyhow, what we were challenging was the way the statute was written. It didn't give an appropriate appeal of constitutional issues. Specifically, it didn't give Mr. Horvath the proper kind of notice that's required under constitutional guarantees in order to protect himself so that he can do the proper things to fix the house, and it didn't give him the appropriate time, and it didn't give him a valid method of challenging that administratively. So we were challenging that de novo in the court, in the trial court, and that's, in a nutshell, in a very quick nutshell, what we were arguing in the civil appeal. At that point in time, when it was raised by Mr. Furtado, we're saying that the trial court should have taken a look at that and said, wait a minute, if I go ahead and hear this case that we know is based upon the same citation, and if the Court of Appeals ultimately were to rule that either as written or as applied, the ordinance or the ordinance was unconstitutional, then I might have a conviction that's based on an improper document, on an illegal or a void document. Now, there's a distinction to be made here, and I understand that. You know, when I recite the jurisdictional requirements and prohibitions of trial courts, you know, when I recite the language, you know, depriving this court the ability to affirm, reverse, and so forth. Obviously, what we're talking about is an appeal, a direct appeal from the same case, and this is a different case, and I understand that. That's why I think at this point in time, if we hadn't raised it, we would have waited. If Mr. Furtado hadn't brought this to the court's attention, as opposed to jurisdictional questions, subject matter jurisdictional questions, we would have waived it. This required, in our opinion, the court to issue the stay, provided we raised it properly, and we say we did. So, at that point in time, there would have been no harm in the court saying, you know, it's up to the Court of Appeals. This is a very interesting issue. I might think it should be handled one way. They might think it should be handled another way. Why don't we just all cool it? Why don't we just wait and see what the Court of Appeals says? And then we can proceed at that time on the criminal complaint. Now, I understand, you know, under the criminal rules, you know, justice delayed is justice denied. But in this particular instance, what we're talking about is constitutional questions, and a short delay to allow this court the opportunity to rule on those issues, I believe would have been appropriate and would have been the proper manner for handling things. Now, Your Honors, I also addressed in my brief some of the basic constitutional questions that we raised within within our civil appeal. I did so as much as anything else, and the court understood what our arguments were. I don't really expect, well, I shouldn't say that. I think, I believe that goes to the reason why we needed to hold matters up, and why this court should now reverse that. Not so much to say we reverse it because we're finding it's unconstitutional here in this case, but we're reversing it so that the court can issue the stay, and so that we can make the decision on the bigger issue, on the substantive issue, the one where we actually have a record, something that the court can look to. It's a very important matter to us. Now, just so the court understands, the citation in this case quoted 24 separate statutes, ordinances. I apologize. One of the things that I think is very interesting is that when I tried to figure out what ordinance applied, you'll see in here that I made an argument that they charged them under the wrong ordinance. Well, I'm as aware as anyone that people can make mistakes. They're off by, one digit. Happens. Of course, it's never happened to me. Just a joke. But, I understand that. But I had real difficulty, and I used the reference librarian at the Sun County Library to try to figure out what ordinance was in effect at the relevant times. And I had a heck of a time finding it. I've cited what I believe to be the case in my brief, but I'd ask the court to pay some attention to that because there's some real confusion.
And counsel, you're just now reaching into that 5 minutes. You may continue or reserve as you see fit.
No, Your Honor, thank you very much.
Certainly.
May it please the court, thank you. My name is Kelly Parker. I'm an assistant prosecutor for the city of Barberton. I'd first like to touch on the first assignment of error and argue that the motion to stay did not bar the city of Barberton from prosecuting an accumulations case. And the reason I say that is similar to the way the court recently ruled in CA 29921 March 25th. Excuse me. And it's that the demolition order that's currently under civil appeal and the accumulations of rubbish and garbage on the same property are two entirely separate issues. The prosecution of the accumulations case, which is a basic health, safety, welfare issue, does not pertain to the defendant failing to correct violations relevant to the demolition of the property or for failing to demolish the property, which I believe the trial court, as you can see in the transcript, considered and heard and reasoned through properly. On March 25th, 2022, this court rejected the appellant's argument and found that the stay injunction enjoined Barberton from taking any action relative to the demolition of the property, and that this case did not involve any action in furtherance of the demolition. So, based on that reasoning, I don't believe that the trial court uses discretion in denying the appellant's motion to continue or stay the prosecution at the time of the trial. Turning to this assignment of error number 2, the ordinance under which the appellant was prosecuted is unconstitutional as applied or written because he was afforded adequate due process. It's not unconstitutional as applied. The authority that Horvath cites, which is a knuckleus case, pertains to adequate notice in an administrative demolition proceeding prior to demolishing a structure. Here we have a criminal case. Like all criminal cases, the defendant is afforded certain procedural rights, specifically those rights found in the Ohio Rules of Criminal Procedure, the right to be represented by counsel, to file pretrial motions, the right to trial, to cross-examine witnesses, or present any evidence of his own. All that was afforded to him on the trial date. It's not unconstitutional as written in this specific case. I argue that because legislative actions are afforded a strong presumption of constitutionality, and a law should not be held unconstitutional on any slight implication or vague conjecture, but only where a court has clear and strong conviction that the challenged law is incompatible with the Constitution. The parties during the ordinance is unconstitutional must prove that beyond a reasonable doubt. Here, the appellant cites the Englewood case, but in the Englewood case, the appellate court found the trial court erred in a 2506 appeal in finding that all administrative remedies were exhausted. Our case differs dramatically. One, it's not a 2506 appeal. It's not an administrative appeal, an administrative decision that is timely filed. And also, the Barberton Property Maintenance Code does indeed have provisions for administrative appeals. That order that he received, and I guess where I would distinguish from what appellant counsel is arguing, is he refers to a citation. That's a notice of violations. The citation comes a year later in the form of the uniform ticket that cites 307.1. But the initial notice of violations was appealable at the time the appellant received it, and he testified under oath that he did in fact receive that notice in April of 2020. That tells him of his administrative right to appeal. And the Barberton ordinances and the property maintenance code, which is a model code adopted by Barberton, they both give him that right to appeal. So statutorily, it is there. For that reason, I don't think in citing an Inglewood case that it's applicable, and I don't think that he set forth the case that the Barberton ordinance is unconstitutional beyond a reasonable doubt. The last point that I will get to is the third assignment of error. I argue that the ticket that the appellant received was adequate to advise him of the offense with which he was charged, and the evidence was sufficient to convict him of accumulations. And I can say with a degree of humility as the prosecutor at the trial court level, that had I known it was cited under 307.1 instead of 308.1, I would have either amended it or had it refiled at that time. And when appellant counsel talks about figuring out which provision was cited, again, I'll draw your attention back to the April 2020 notice of violations. At that time, the city of Barberton adopted a model code, which was the 2006 property maintenance code. After the issuance of that notice of violations, the Barberton City Council adopted a new model code in the sense that they said, you know what, we're not going to use the 2006 version, we're going to use the most recent, which comes to 2021. So after that notice, and between the time when the citation for the accumulations violation was issued, 307.1 in that model code got changed to 308.1. As best as I can figure out, that is why the citation was inaccurate in the numerical identifier for the code section. But what I do argue is that even though I wish that didn't happen, I don't believe it was fatal to the prosecution of the criminal rule 7. Because what I argue is that the defendant was not prejudicially misled by the clerical error in the citation that was issued at that particular time. And I believe also that it's somewhat inconceivable that Horvath believed he was being prosecuted for anything but an accumulations violation when you look at the direct language of the citation that was issued to him, which said accumulations on exterior of the property. That, in combination with the notice that was issued in April 2020, and not the citation, but the notice that was issued a year earlier, that had 307.1, which was the accurate law at that particular time, which defined what rubbish was, or accumulations of rubbish on this property actually was. I believe it was adequate notice to not mislead the defendant in this particular case. And I'd also argue that the appellant could have filed for a bill of particulars or other discovery procedures. He could have raised the issue at the trial court. He didn't raise the issue at the trial court. And all the evidence and the testimony in this case was very, very specific to the accumulations at the property and the photographs, exhibits 2 through 6, that show the accumulation of these materials on the property. And I don't believe that the defendant, which the appellant, has demonstrated that he was misled by that ticket that was issued to him, and therefore there's no prejudice in the way that the ticket was written at that time under these circumstances. And finally, I argue there's sufficient evidence to support a conviction for accumulations of rubbish on the property. Specifically, there are 6 photographs entered as exhibits and admitted and considered by the trial court in this matter. Officer Sykes, who is a code enforcement officer, licensed residential building inspector, and licensed commercial building inspector employed by the city of Barberton, testified that accumulations from the approximately 1 year that he inspected the property just became worse over time, not any better. He testified to storage bins, items covered by tarps, tires, piles of unstacked wood, bags of mulch with plastic deteriorating due to the weather conditions, hot tub covered with the tarp that was presumably full of rubbish, and his concerns based on his training experience that would lead to rodent harborage, breeding for pests like mosquitoes, hold stagnant water, and its unsightly appearance and health and safety could be made known. So therefore, I would just ask this court to overrule the assignments of error 1 through 3, and I'm available for any questions if you have any.
Seeing none, thank you.
Thank you, Your Honors, Counsel. I'm going to say that I won't take 5 minutes. Regarding the first part of Counsel's discussion, regarding the stay, the original citation that was issued in August of 2020 merely recited the ordinance. It didn't say what. That's the whole nature of at least one of my arguments in this civil action. When counsel says that, well, you were put on notice that there were accumulations, no, we were put on notice of an ordinance as apparently it was in effect at the time. By the way, as best I can tell, the ordinance was changed October 26th, I believe it is. I haven't agreed. It took me some time to track it down. October 26th, 2020. So in August of 2020, he was cited for 24 separate things, one of which was an ordinance that talks about rubbish and garbage. Well, we know it's not garbage, so the only thing it could have been was rubbish, I guess. Doesn't say what, doesn't say what's to be removed. What it says is, here's the statute, here's the ordinance, figure it out yourself. It's exactly the situation that former Judge Sowers faced in the Knuckles decision that I've cited in my brief down in Stark County. You have to tell us what it is that you want us to pick up. I mean, it doesn't have to be, as a lot of the traffic cases that we've cited say, it doesn't have to say, you know, the blue tarp with a hole in it dated 1956 from, you know, issued by, I don't know, Sears. But it has to say something enough that it gives me a reasonable opportunity to know what it is that's supposed to be cleaned up. And it doesn't. That is the very substance of the Knuckles decision. Now, relative to the Englewood decision, I'd ask the court to pay particular attention to that one. It talks about an effective appeal, not just an appeal. You can't just say, well, you can appeal. It's not going to do you any good. But you have every right to stand on your head and try and tell us that we're idiots. And give us absolutely no procedure for whether or not you can present evidence, whether you can cross-examine witnesses, whether you can call witnesses. More importantly, or equally as important, I'd say, the appeal in our case, the appeal right, the administrative appeal right, only provides for very narrow kinds of questions, one of which is not constitutionality, by the way. It's whether the law is being applied in a manner consistent with the purpose or something of that nature. I've cited it in the brief. But it is so limited that it is nugatory. It doesn't exist. That's what we've argued. And that's what I believe the evidence shows. I understand it's in the civil appeal right now, but it's one of the reasons why it was so important that we hold up, that the court hold up its decision below, pending the outcome of the civil appeal. Relative to the ticket being adequate to apprising of the offense, again, I'm not going to hold Mr. Parker or any other attorney to a standard where he has to get every digit right, so long as the client understands what it was. I understand that. We're busy people, it happens. But in this particular case, Mr. Horvath testified, it was really uncontroverted, that given the status of this case, as it is right now, the trial court has said you don't have a right to appeal, you don't have a right to have your case heard in the common pleas court. Well, it hasn't ruled that yet. What it ruled is it won't grant the temporary injunction because the temporary injunction, or the preliminary injunction, relies on this court's jurisdiction and you don't have jurisdiction. So it hasn't yet thrown the case out, but it's given us a pretty strong indication it will.
And counsel, unfortunately, I need to advise you that you are in excess of your allotted time.
May I finish my sentence?
Certainly.
And so Mr. Horvath testified that all that was necessary while this was pending. They were items that he needed to repair the property in the event that we got the chance to repair the property. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. We have a little bit of time before our next scheduled oral argument this morning, so the court will be adjourned until 11:30. Again, thank you both and have a great day.
Thank you, Your Honor.